So good afternoon. You've all been very patient waiting for our keynote speaker, but I think we've all been edified by what we have heard. Now, as you heard, I am a professor of international law, and international law has played a sort of backdrop role in this discussion so far. But what I want to highlight is that just as our keynote has addressed throughout her career, law has been a tool of oppression as well as liberation, and international law is no exception. So even though we like to celebrate it, and in fact, I'm on the board of the Center of Reproductive Rights, which much of its work is using international law on behalf of reproductive rights around the world. So that, for example, through the efforts of that center, as well as many others and other NGOs, we have been managed to get rulings that denial by a government of access to an abortion for a teenager after rape can constitute cruel and inhuman treatment and perhaps torture under the Torture Convention, can violate the rights of equality under CEDAW, can violate the rights of the child under the Rights of the Child Convention. So we like to think that international law is on the side of liberation. But it wasn't so long ago that it wasn't, and I'm not so sure that it doesn't remain gendered today. So that for much of international law's life, it has been, in fact, a tool of seemingly neutral rules that functioned as male privilege in the construction of hierarchical rules and dominant lawmaking actors, and made people, yes, half the planet invisible along the public-private divide that we just heard about. In this continent, in the US, feminist perspectives on those silences didn't come until 1991, when the American Journal of International Law published Christine Chinkin and Hilary Charlesworth's path-breaking critique of international law. When those ideas arrived, they had a transformative effect on the field, but we're still working that out. So that challenge continues. Our sources of law, our state centricity, the interplay between power and law, how our international institutions still fail to mainstream these issues, and how others, and not just states, can still not be made accountable. So just by way of self-reflection, to many of you who do international law, and after all, this symposium is being hosted in part by the Journal of International Law, I call attention to, at least in the US, the leader of sex harassment law, my former colleague at Michigan, Catherine MacKinnon. And here's what she had to say not that long ago about the field of human rights. And I think at the time she was writing, she was not wrong. Quote, "Human rights principles are not based on the experience of women. When things happen to women that also happen to men, like being beaten and disappeared and tortured to death, the fact that they happen to women is not noted in the record books of human suffering." And here's another quote that I like about my favorite word in international law that my students always invoke, sovereignty. Sovereignty has been a very strong aspect of international law. We defend it at every stake. Here's what MacKinnon had to say about it. Sovereignty is an element of male ideology. The notion of sovereign dominion structures legal recourse in the form of doctrines of jurisdiction at every level of procedure, from the domestic through the international. It begins at home, a man's castle. Historically, women have had to leave home to get justice within it, overcoming a systemic reluctance to intervene in what are called domestic conflicts in the private sphere. Women got local regulations, state or provincial laws, as close to home as possible. Laws against rape and domestic violence continue to be interpreted and implemented through a familiarity exception, meaning the closer the man is to the woman, the more he can violate her. So our keynoter has given life to these warnings, has used international law throughout her career, but has also used it in a way that I think is concrete, on the ground, and throwing a harsh light on how international law as well as domestic law has rendered half the world's population less than human. So what we wish to celebrate here through our keynoter is how not just her, but the folks that you've been hearing from have actually shown how violations of equality may occur as a result of social and cultural as well as legal practices through actions at home as well as in the public sphere, whether resulting from indirect or direct state action, whether systemic and inadvertent or intentional. You have the bio of our speaker, and I'm not going to repeat it here, but I'm proud to say that she was a graduate of our school, did take international human rights law with my colleague Philip Alston, and has used it in her work. If you take a look, you will see that she's contributed to the drafting of laws in her country, including the 2013 Criminal Law Amendment to the Law Against Sexual Assault, the Protection of Children from Sexual Offenses Act from 2012, the Prevention of Torture Bill from 2010. And you also will know, and it's in our program, that she was named in 2013 to Time Magazine's list of 100 most influential people in the world. What you probably may not have realized is that what Time used in describing her was the comparison to acupuncture. The human body is a network of pressure points, it said. The healer will apply force, hoping to bring about change, which is an apt description of her entire career. Her work as human rights lawyer, advocate for women's rights, has meant that she presses down pretty hard in her determination to force an often recalcitrant political and legal system to change what they refuse to do, including with respect to rape in Delhi, in a particular prominent case. So Time described her voice as loud, uncompromising, raised again and again in the rambunctious theater of Indian TV. Justice and equality, however distant, are the goal. She's here to remind politicians that nothing else will do. If you look further, you will also see an interview with Ms. Grover, and you will see both the practical and the visionary sides right in that interview. So she was asked about why isn't there enough funding towards assistance to crime victims, including the victims of rape? And here's what she had to say. Yes, we have paralegals to help women. Most women will not be there in a position to engage counsel for various reasons. The prosecutor is not going to hold her hand because the prosecutor has to deal with many, many cases. The survivor is the last one, actually, who gets to know what is happening in her case. And the state says, we step in for the women. This is a crime against society, but when you step in for somebody, you owe an answer to that person. You owe a duty to that person. You don't owe a duty only to something called an abstract society. If we have paralegals who will stand by her, who will keep her informed, then we have to pay for them. That is, they don't pay for themselves. We should not expect these people to do good all by themselves and all on their own pro bono. That's the practical side of our keynote. And then there's the visionary side that reminds me of some of those quotes we just heard from McKinnon. Women, she says, are subject to violence, and violence is very deeply ingrained in us. Our demands for hanging and castration of perpetrators are only an amplification of that violence. And I think we need at some point to start linking sex crimes with very, very serious violence that we generally have in society, which we don't talk about. Indian society is amongst the most violent and brutal of societies. The sheer brutality with which we treat people whom we assume are powerless, whether it's domestic help, whether it's workers in factories, or anyone else whom we think is powerless. There is a connection. We have to make those links. We haven't even started. Well, she hasn't even started. Let's welcome Ms. Grover.
Thank you, Professor Jose. I had no idea he had looked up some random interview which I couldn't recall what he was going to say that I had said. Thank you. It gives me great pleasure to be here and to speak at this symposium, for it was 10 years ago in 2005 that I took a mid-career break from litigation and advocacy in New Delhi, India, and came here to do my master's. I was part of a group, a fellowship that doesn't exist in NYU any longer, called the Global Public Service Fellowship, which was awarded only to people who had been working around these issues in the Global South. I was the last batch, I believe, of that fellowship. And I think for all those reasons, this conversation today, which Hannah and her team at JILP and the Rubin family have made possible, becomes even more crucial, because at this juncture, not only on the issue of women's rights, but perhaps on all issues affecting human life, conversations between the global South, the global North, between the East and West is the only way forward. And I do hope NYU reconsiders beginning that fellowship for the global South. It would enrich the global South as well as NYU. It is a special honor to speak at NYU, and having had a very, very rich panels on Mexico, Nigeria, and of course the unenviable task of locating myself between the two panelists on India. I would make a confession, I lean clearly towards Rangita's position. Perhaps it's to do with the training of law and the discipline that I come from. What I'm going to try and do today is to try and map out the different ways in which the issue has been addressed in India. And I hope somewhere we can try and see what is the argument that I'm making for the conjunction that does exist to my mind between human rights and women's rights, even within plural legal systems. There's already been a background set, so I'm going to quickly get to the main chunk of what I wish to present here. Pluralism of the modern Indian legal system in the sphere of personal laws is a colonial remnant. The religious laws came to be retained in the sphere of family, while secular laws were enacted to govern relations of trade, commerce, and crime to serve the interests of the British colonial regime. The British colonial state thus institutionalized the dichotomy between the private and the public, subjecting the private sphere to laws of religion or tribal customs. Though of colonial origin, different personal laws were retained even at independence. Despite the establishment of a republic on the basis of a constitution with a charter of rights for citizens, personal laws continued to make Indian law and society unequally committed to social and political equality. It was in the Constituent Assembly debates that the issue and the debate around personal laws was subsumed under the debate which was referred to by Gopika, called the Uniform Civil Code, or the UCC. The UCC, which was at that time advocated as a tool, as a device for unifying the emerging nation state. And I quote one of the members, "We are in a stage where we must unify and consolidate the nation by every means without interfering with the religious practices. If, however, the religious practices in the past have been so construed as to cover the whole field of life, we have reached a point," sorry, I have the wrong, right. I wish to read only the part on the unification quote and not the other quotes. It was seen as a driver for unification, for strengthening the national integration. In the Constituent Assembly debates were also women like Hansa Mehta and Maharani Amrit Kaur. Hansa Mehta, who was also part of the UN drafting of the Universal Declaration of Human Rights. Human rights is therefore not an alien Western concept which was adopted and absorbed into the Indian Constitution. The most ardent votary of the UCC, Dr. B.R. Ambedkar, a Dalit, the chairman of the Constituent Assembly, countered the voices that sought both conservative Muslim voices as well as Hindu conservative voices, which sought the retention of personal laws based on religious lines. Moving ahead from the Constituent Assembly debates, which on not being able to resolve the issue, and in face of the opposition from all religious communities, and here it would be the conservative forces which represented them in the Constituent Assembly, it was decided to place the UCC, the idea of UCC, in Part 4 of the Indian Constitution, which is the non-enforceable, non-justiciable directive principles of state policy, and I quote, "The state shall endeavor to secure for the citizens a uniform civil code throughout the territory in India," Article 44. I've titled this paper "From Uniformity to Equalities," and I'll explain what I mean by where we stand today on the issue of having gender-just laws. Almost 7 decades after independence, the demand for a UCC frequently enters the national discourse, either through judicial verdicts or in political party election manifestos, or as a demand by certain socio-political organizations, and resurrected as an unfinished agenda in the building of the Indian nation state. The concept and articulation of UCC is today deeply contested, an idea which in its origin was proposed as a unifying force, today has mutated and become a device that provokes divisions, fear, and alarm in a highly surcharged and polarized socio-political environment. The debate around UCC in India revolves around certain themes. First, that UCC is the panacea to deliver women belonging to the religious minority community, read Muslim women, and tribal women from all the suffering and injustice inflicted on them within the family and home by virtue of their religion or customs and tradition. I will probe whether the UCC is at all the response required for the iniquitous status of women across all communities and religions. Second, what are the institutional mechanisms and processes through which this issue can be addressed? Here I will explore a few sites. Is the Indian Supreme Court best suited to lead the charge towards gender equality? To answer this, I will examine the court's jurisprudence and its approach to the issue over the last 6 decades, in particular, whether the courts have vindicated the constitutional guarantees of equality and non-discrimination for women. I will also draw your attention to the tone and tenor of the court in adjudicating these cases. This is important because it helps to understand whether the court can be the primary site through which change can be ushered. Another site explored here is the community itself. What are the prospects for reform to come from within the community, whether a religious minority or the tribal group, whose women are perceived to be at the receiving end of the discriminatory personal law? 2 aspects are relevant here. First, will the community be receptive to change? This issue cannot be answered in the abstract and will have to be located in the current political context. Secondly, who represents the community? Who constitutes the legitimate expression of the aspirations of the community? Since the 1990s, there has been an aggressive rise of the Hindu right-wing political party, espousing the political ideology of Hindutva, which is different from the religion, Hinduism, and the political project of Hindu Rashtra or Hindu nation to shape India into a unitary Hindu state. The BJP, which is the ruling party in India today since May 2014, and their affiliate Hindutva organizations clamor for UCC is not motivated by the plight of women, as Muslims and Christians have been attacked in communal riots and women's bodies targeted and sexually assaulted to dishonor and disgrace the minority community. Imposing the UCC is seen as part of the agenda to erase the identity of the religious minorities with personal laws as markers of the identity. In 2015, and the next site that I explore, should we turn to the state through the parliament to take steps to bring UCC from the distant horizon of directive principles to the justiciable realm of fundamental rights? The ruling party in India enjoys a brute majority in parliament and so can attempt to propel the UCC agenda, which featured in its 2014 election manifesto. Interestingly, the demand for UCC is now couched in terms of women's rights and modernity. Finally, but perhaps most significantly, the response of the women's rights movements and the feminist movement in India. keeping in view the regressive history of the codification of Hindu personal law and its role in the demand of a UCC by the right-wing majoritarian forces, the women's movement in India has consciously moved away from the demand for a uniform personal law to a multi-layered and complex discourse as well as a range of strategies. This understanding informs the law reform campaign, which has achieved legislations like the Protection of Women from Domestic Violence Act 2005, referred to earlier, and the law against dowry, and the constitutional challenges to the unequal provisions of codified and uncodified personal laws. I will now quickly rush us through some of the judicial verdicts, largely by the Supreme Court, which would perhaps help us understand that how has it reacted and responded to personal law challenges raised. And it would be important to mention here that some of the challenges were taken to court by feminist women in their capacities as mothers, as wives. And as was mentioned by Rangita in the earlier panel, the lawyering by someone like Indira Jaisingh, a senior advocate at the Supreme Court, was also feminist lawyering, which helped shape the jurisprudence, or at least drew critical attention when the Supreme Court did not vindicate the rights. Gender equality can be located in 3 provisions of the Indian Constitution's Bill of Rights, known as fundamental rights: the guarantee to equality before law and equal protection of laws, Article 15, which prohibits discrimination by the state on grounds of sex and allows the state to take affirmative measures for women, and Article 16, which prohibits discrimination in employment by the state. The court, particularly the Supreme Court and High Courts, have been a critical site where the issue has repeatedly been a subject of judicial determination. On almost each occasion, it was a woman belonging to one or the other religious denomination who approached the court with the hope that the constitutional principle of equality and non-discrimination would protect her rights and promote her dignity. I have categorized the judicial response since the 1950s to the present under the following broad categories. First, judicial reluctance to apply the constitutional rights framework. Very early in 1952, the Bombay High Court held that personal laws would be immune from constitutional challenge. Thus, at the very dawn of independence, the private or domestic sphere was left to the dictates of culture and religion, placing women's lives outside constitutional protection. The reluctance of the Supreme Court to use the constitutional framework of equality as the touchstone against which each law must be measured was evident in the judgment of Mary Roy, where a Travancore Christian Succession Act giving unequal inheritance rights was challenged by a Syrian Christian woman. The Supreme Court, however, simply held that since this law had now lapsed and had been replaced by a more equitable law, there was no reason to decide on the issue of the unequal provision of the law. In Madhukeshwar versus State of Bihar in 1996, certain provisions of the Chota Nagpur Tenancy Act applicable to tribals was challenged as unconstitutional, for it restricted succession to the male line. Once again, the court refused to test the tribal custom of inheritance and held it is not desirable to declare the customs of tribal inhabitants as offending Articles 14, 15, and 21 of the Constitution. The court resorted to the reading down rule of interpretation and provided a limited right to agricultural land, a right to livelihood. Adopting a refreshingly different judicial approach in 1996, and therefore there is no consistent or linear jurisprudence that we will see here, while adjudicating upon whether a widow was an absolute owner under the Hindu Succession Act, a 3-judge bench held the basic structure permeates equality of status and opportunity. The personal laws conferring inferior status on women is anathema to equality. Personal laws are derived not from the Constitution but from religious scriptures. The law thus derived must be consistent with the Constitution test. Otherwise, they would become void if they violate fundamental rights. In the Geeta Hariharan versus Reserve Bank of India case, the constitutional validity of the provisions of the Minority and Guardianship Act of Hindu law was challenged because it did not recognize the mother as the natural guardian, but only after the father. The court again, instead of declaring the provision unconstitutional, because it was discriminatory, deployed the legal device of reading down to widely interpret after to also mean in the absence of father, so as to include the mother as the natural guardian, but did not interrogate the patriarchal norm of the family. In Shabnam Hashmi versus Union of India, the petitioner, civil rights activist in India, challenged the adoption law, the Muslim law, which did not allow Muslims to adopt and confer the status of a child and not just a ward to the adoptee. The adoption was done under the secular law of the Juvenile Justice Protection Act. And the Supreme Court said that yes, the secular law would be applicable, but citing the principle of judicial restraint, and this is a recent judgment of 2014, citing the principle of judicial restraint did not delve into the validity of the Islamic law on adoption. The next category that I make is judicial foray into interpreting religious text. The most sensational case on this issue is the Shah Bano case, where Shah Bano was awarded maintenance and approached the Supreme Court against a very paltry maintenance that she was given by her husband in a marriage where she had been married for about 30, 40 years. And when the case went up to the Supreme Court, instead of arguing and declaring that yes, she has been awarded maintenance under the secular criminal law, which is meant to prevent destitution and is her right, the Supreme Court delved into a very elaborate interpretation of the Quranic text. In fact, it went into looking at the surahs, the ayats were at length discussed in the judgment. The All India Muslim Personal Law Board intervened in the case. The judgment became an arena of contestation between the custodians of Muslim personal law and the Supreme Court on the true interpretation of Quran. The constitutional paradigm of fundamental rights was reduced to a marginal footnote in the jurisprudential discussion. What followed was a political storm, with the orthodox and fundamentalist Muslim leaders raising the alarm that Islam was in danger and Sharia was under threat. The Muslim religious leaders proclaimed that the Supreme Court had transgressed its authority and usurped their theological role of interpreting the Quran. The public debate was framed in terms of an attack on Muslim law, which was stated to be the exclusive reserve of Muslim religious leaders. The central government, led by the Congress party at that time, apprehensive that it would lose the majority of Muslim votes, succumbed to the electoral calculus and hurriedly passed the Muslim Women's Protection of Rights on Divorce Act 1986, which removed Muslim women from the domain of the hitherto uniformly applicable law on maintenance. The most disturbing feature of the Shah Bano judgment is that the Supreme Court meandered into the interpretation of a religious text rather than foreground the rights of a Muslim woman on the primacy of fundamental rights and the guarantee of equality for women. The Supreme Court did not hold the Muslim personal law discriminatory or unjust, but rather chose to reinterpret the Quran in a way that would place a religious obligation on the husband to maintain his divorced wife. Consequently, plural legal systems were further reinforced in the country. Bruised by the aftermath of the political storm that led to the enactment of the Muslim Women's Protection of Rights on Divorce Act, the Supreme Court, while dealing with the constitutional challenge to the newly minted statute, approached it with maturity in the Daniel Latifi case and refrained from any reference to religious texts and instead observed, in our society, whether they belong to the majority or minority group, what is apparent is that there exists a great disparity in the matter of economic resourcefulness between a man and woman, and said that all Muslim women must be given fair provision on divorce, and interpreted the new law in a manner that the Muslim woman did get the rights that she would otherwise have got under the secular law. On 4th November 2015, the Gujarat High Court, in a recent judgment, while determining whether the offense of bigamy would apply to Muslim men contracting more than one marriage, after a lengthy analysis of the Quran, concluded that Islamic law did unequivocally permit polygamy. Once again, the court took it upon itself to interpret Islam. And a specific subheading in the judgment reads as, "What is the message of the Holy Prophet Muhammad, which is reduced into writing in the form of the Holy Quran?" This is earlier this month. Almost as an afterthought, the court engages with the implications of polygamy for the constitutional guarantees of equality and non-discrimination and the prescribed limits of the right to freedom of religion. The court, however, concludes that in the absence of a uniform civil code, the offense of bigamy will have no application to the adherents of Islamic faith. The third categorization is the judicial anxiety to rescue women. When confronted with cases where a man had resorted to religious conversion or otherwise entered into bigamous relations, citing the Islamic sanction for polygamy, the judiciary has expressed anxiety for the fate of the first wife, an anxiety that is notable in its absence from judgments on inheritance laws, which blatantly discriminate against women. In the Sarla Mudgal case, when a Hindu man converted to Islam to contract a second marriage, the Supreme Court said when more than 80% of the citizens have already been brought under the codified personal law, there is no justification whatsoever to keep in abeyance anymore the introduction of uniform civil code for all citizens in the territory of India. When it talks of the 80%, it's obviously referring to the Hindu law, which has been codified over a period of time, not necessarily being equitable, it's simply codified. But the court did not make that distinction clear. An envy of Muslim man enjoying polygamy with legal sanctity lurks in India's judicial and political narrative, even though studies demonstrate that polygamy is rampant among Hindu men. This further feeds the propaganda by the Hindu right wing of Muslim men as sexual predators, and Muslims, through children born from their four wives, will numerically outstrip Hindus in India. The next category is judicial abdication in favor, judicial advisories to the legislature. From the Shah Bano case onwards and before, the Supreme Court has repeatedly asked the legislature, the government, to enact a uniform civil code. In a case brought to the Supreme Court by the Ahmedabad Women Action Group, pointing out discriminations on various grounds, instead of dealing with the aspect of discrimination, the court simply made an observation that the legislature must enact a uniform civil code. Last month, in October 2015, the Supreme Court, while hearing a matter where a Christian man had questioned the provision which requires a Christian couple to be judicially separated for 2 years, as compared to a Hindu couple, which is required to be judicially separated for 1 year before seeking divorce. The judges made an oral observation that there was total confusion over the incoherent stipulations about marriage, divorce, adoption, inheritance, and asked the Solicitor General of India to come back in 3 weeks with instructions on the government's view. This was the third time this year the Apex Court has spoken on Uniform Civil Code and wants a categorical answer from the government. It is important to underline here that the prime concern expressed by the Supreme Court was to bring uniformity and clarity and not gender justice. The last category that I have here is the judicial prioritization of fundamental rights. A glimmer of hope can be found in a few judgments which may pave the way forward for gender justice as envisioned in the Fundamental Rights chapter. In a departure from the judicial trend detailed earlier, in a 3-bench judgment in John Valamotam, where the issue before the court was that can a Christian man bequeath through a will for charitable purposes or religious purposes, the Supreme Court held that by discriminating between Christians and non-Christians, this provision is unconstitutional and it was struck down. I would, however, point out here that the challenge in this case to personal law was not based on the basis of gender discrimination, rather sought parity between different religious communities. Again, in 2015, in a recent case where a Christian woman sought to be declared the guardian of a child that she had outside wedlock and not to name the father of the child, the Supreme Court held that she could be allowed to, they recognized her right, and the Supreme Court held in today's society, where women are increasingly choosing to raise their children alone, we see no purpose in imposing an unwilling and unconcerned father on an otherwise viable family nucleus. And I cite this here also to show that the conceptualizing of the family is also changing, the nature of relationships is changing, and therefore it is not as though the normative form or the heteronormative form is not being challenged and cannot be integrated with the guarantees of gender equality. However, a linear progression on the path of gender justice through judicial verdicts of the Supreme Court is not very likely. On 16th October 2015, the Supreme Court, in a case relating to the Hindu Succession Amendment Act, which had given women co-parsonary rights in the Hindu undivided family, while interpreting the law, said that it will only be available to those women where the father was living at the time of the enactment of the law, of the amended law, in 2005. And as I mentioned earlier, a word about the petitioners. Sarla Mudgal and Shah Bano were women in distress who moved the Supreme Court to urgently seek redress for the harm and injury caused to them. Geeta Hariharan, Madhu Kishwar, Shabnam Hashmi, and Awag are all women with feminist thinking and are actively engaged in social movements. And they challenge gender-based discrimination embedded in personal laws. The former evoked in the Supreme Court disquiet and concern, leading to the issuance of advisories to the government to fulfill the promise of enacting UCC. The Supreme Court, however, refused to seize the opportunity to strike down as unconstitutional a discriminatory statutory provision. If one looks at cases which are not to do with, which do not deal with personal laws, employment, service laws, there the court has been very willing and unhesitant to hold that if a man contracts a second marriage, then he will lose his government job. And because over there the issue of gender, it's not the issue of gender justice that comes in, but it is about service and employment legal regime, the Supreme Court has no reluctance or hesitation in stepping forward. Again, in issues relating to employment of women at hotels or other bars where liquor and alcohol is served, the principle of equality has been upheld very clearly by the Supreme Court. However, no such clear articulation based on the fulcrum of gender equality is found in judgments relating to marriage, divorce, maintenance, inheritance, which fall within the purview of personal laws. In those cases, jurisprudence has created a false dichotomy between freedom of religion and women's right to equality. The next site that I will quickly touch upon is to look at the religious minority community, both the Muslim and Christian. To look at Muslim women, I'm going to look at the example of an organization called the Bharatiya Muslim Mahila Andolan, which would translate into an Indian Muslim women's campaign. The BMMA, composed and initiated by Muslim women, advocates criminalizing polygamy, making 18 years the minimum age of marriage, and abolishing the practice of triple talaq. A recent survey done by this organization found that 60% triple talaqs were unilaterally given by men, and an overwhelming 92% of Muslim women wanted these practices to be removed. The BMMA, as has been referred earlier by a panelist, has also drafted a model Nikah Nama, which seeks to bring equality and parity between the spouses through compulsory registration of marriage and other provisions. The campaign of BMMA, however, draws upon the Quran and believes that the Quran accords equality and dignity to women, and it is largely due to misinterpretation and distortion that discriminatory practices have become commonplace in the Muslim community. The BMMA opposes the introduction of a UCC and sees it as an assault on Article 25, which guarantees freedom of religion. Another group which is just very nascent and is constituted by women who have been part of the feminist movement in India, called the Bebak Collective, has been traveling in different parts of the country with a feminist perspective and is now coming together to hold its first national convention early next year. They seek to foreground the absence of social and economic rights of women rather than the issue of personal laws. The Bebak Collective disagrees with BMMA and does not seek to find answers within the Quran. It's important to understand this because I think when we look at who is the religious minority community, they are not monoliths. They are not only divided along lines of men and women, but different and diverse perspectives coexist within the religious minority community. Interestingly, the All India Muslim Personal Law Board, which is in many ways a self-appointed authority on Islam and has been repeatedly and regularly intervening in all major petitions in the Supreme Court, has refused consistently to engage either with the BMMA or any other Muslim women's formation. Last week, for the first time, the All India Muslim Personal Law Board has invited different Muslim women's groups who have been seeking parity to come to its meeting. This is a new step, and we still need to see what the outcome would be. On 14th November 2015, a news report stated that AIMPLB has for the first time decided to extend an invitation to women to join in its working committee and its general body as a fair representation of women. Currently, there are only 7 women in the 51-member AIMPLB. The BMMA and other Muslim women's organizations have not yet responded to this invitation. The timing of this invitation compels one to wonder whether the aggressive call from the current political dispensation and the courts for a UCC, combined with the release of a public statement and report by BMMA announcing that they would stage public protests for an end to triple talaq and polygamy, have forced the AIMPLB to extend this invitation. A look at the Christian women's community. While in the Indian public imagination, as well as in the judicial discourse, the issue of UCC is largely fixated on Muslim personal law, which has been described as, and I quote, barbaric, backward, and unjust. This is by a former Supreme Court judge. Few have been heard to be exercised over the unequal and discriminatory position accorded to Christian women under the Christian personal law. The Christian women's organizations, mainly led by the YWCA and the Joint Women's Program, have navigated through the terrain of the clergy, the church, the state, and parliament to reform Christian personal law and to get more equitable rights of divorce for Christian women. For a moment, let's go to the northeast of India, where 12% of the tribal population in India live. The Indian Constitution, through the 6th schedule, guarantees to the scheduled tribe population in the states in the Northeast the right to observe their diverse customary laws and practices and retain their own tribal systems of internal governance. The unwritten tribal customary laws, recognized as binding by the communities, interfaces with the larger corpus of law decreed and administered through formal state institutions. There is a wide diversity amongst the tribal population here. However, for most tribes, their customary laws are intrinsic to their identity and constitutive of their culture and their tradition. These customary laws play a significant role in binding the community and maintaining tribal solidarity and identity. I would, however, add a word of caution here that there is often mystique and romanticism attached to customary practices of tribal communities. Customary laws are gendered in that they define the role of men and women. I've drawn upon 2 studies, one done by Walter Fernandez and Sonjay Borbora, and one by a women's rights organization, Partners in Law and Development, both of which conclude that there is inequity in the inheritance rights, that women do not inherit immovable property, and that particularly in village councils and village traditional adjudicating bodies, women do not hold any position and are rarely invited to participate or speak in them. Even when the tribe is matrilineal, it is the man in the family who is in charge of managing and deciding what will be done with the property. The interface with modernity, and Professor Muna referred to this, has not necessarily led to gender equity. In fact, it has led to disintegration of whatever communal rights they had over land and common property resources. the titling of land in individual names further impoverishes women who were anyway trying to exercise certain rights in control and access of that property. So the skirmish with modernity does not necessarily in itself lead to a more equitable customary law practice. In 1994, the Arunachal Pradesh Protection of Customary Laws and Social Practices Bill was legislated. It offered a blanket protection to all customary laws, including polygamy, child marriage, and limitations in inheritance rights for women. Women's groups from Arunachal protested and appealed for the insertion of an additional clause in the bill that qualifies legal protection to customary law only if it upholds the interests of women and children. Despite this, the bill was passed by the State Assembly and sent to the President. For reasons which are external to the dynamics of the issue, that bill did not receive assent of the President. However, it was not due to the advocacy of the women's groups being successful. In the process of codification of customary laws, women are rarely involved, as was seen during the codification of two laws in Arunachal. Through this compilation, all forms of physical punishment, including imprisonment, have been excluded from customary law. Compensation is the only punishment retained, even for the most serious offenses such as forced marriage and rape. Education, political participation in general elections has also brought about new thoughts and change. The 73rd and 74th Constitution Amendment in India creates 33% reservation for women in municipal bodies. A similar law was passed in the state of Nagaland. When it was not implemented, the Naga Mothers Association, a traditional body there, a traditional formation there, went to the High Court and has now reached the Supreme Court seeking implementation of the law. The High Court said the law will have no application to Nagaland because there is a particular constitutional provision which gives protection to customary laws of the Naga tribes. The persons challenging these laws in the Supreme Court are also women from within the Naga community. The dismantling of customary laws and institutions would lead to the destitution of tribal communities. Land and other resources are integral in shaping of customary laws. What I would argue here, insofar as customary laws of tribal communities is concerned, that we would have to contextualize it. In the northeast of India, from the time of the emergence of the Indian nation state, there have been movements of insurgency and rebellion challenging India's territorial claim over some states of the northeast. Yet, and much of it has been actually enforced through militarized presence as well as laws which are draconian. Today, with the new liberal economy making intrusions into the Northeast, where acquisition of land and natural resources is the main driver of economic change, tribal communities are under greater pressure. However, to say that there is no discrimination or there is no inequity or that women from within the tribal communities are not seeking change or not seeking equality would be misleading. In 2015, should we turn to the state through parliament to take steps to bring the UCC? In response to the BJP's shrill cry for imposing a UCC on all communities, the BMMA issued a statement. Article 25, which is the article guaranteeing freedom of religion, gives the right to all, including minorities, to have a personal law based on respective tenets of different religious communities. Under this provision, we demand a gender-just reform in the Muslim personal laws based on the Quranic values of equality and justice. The court goes on to say that they would not accept the Hinduization of all laws and social practices. The recent events of targeted violence have led to an atmosphere of insecurity and deep sense of fear within the Muslim community and amongst all minorities. Any talk of UCC is only adding to the strongly felt sense of hurt and alienation. This atmosphere of intimidation does not help the cause of women's demand for justice at all. It appears that for the right-wing groups, UCC is another stick to beat the minority community with. There is also a strong fear that in the name of UCC, Hindu marriage laws will be imposed on all other religious minorities. Similar fears and anxieties have been expressed by the Christian Secular Forum. Many commentators have said that UCC is today being used as a stick to beat the minority communities. So the UCC has become a weapon in the hands of the present political dispensation to advance the objective of a Hindu nation, which is in contravention of the letter and spirit of the Indian Constitution. The challenge that this poses is how do we move towards gender justice, and can we do so without joining forces with the right-wing brigade, which is raising the issue for instrumental or politically expedient reasons. And in their own vision, they conceptualize a subordinate position for women in the family and in the public sphere. Any discussion on the plural legal system would be incomplete without exploring the question of access to justice. Why do women turn to informal legal systems? And Gopika addressed this issue. Here, when we talk of access to justice, I would say we should measure it not only in terms of awareness of the law and legal systems, availability of legal representation through lawyers, provision of adequate legal aid, prohibitive costs of securing legal representation, or filing petitions in the court, which place courts geographically and financially beyond the reach of women. The high pendency of cases, with arrears peaking at 61,000 cases in the Supreme Court alone. Even where laws such as the Protection of Women from Domestic Violence Act have statutorily mandated that interim protection against domestic violence must be given within a period of 3 days, and the entire complaint must be decided within a period of 60 days. In practice, interim orders sought by distressed women take months, and cases go on for years. It is no surprise that the formal legal system itself is increasingly resorting to alternative dispute resolutions, mediation, lok adalat, plea bargaining to lower the burden of cases. In all these, strictly speaking, juridical principles and processes are compromised in favor of efficiency. Another aspect which I think is important to consider when we look at access to justice, the implementation or enforcement of court judgments. And orders is another major challenge, as judicial verdicts awarding maintenance or alimony are often ignored, leaving women with little remedy rather than to return to the same forum through contempt proceedings. The non-enforceability of judicial verdicts is particularly pronounced where orders are passed giving redress to women. This is both because men enjoy greater social currency and the system displays an institutional bias against women in its functioning. Bias, the charge that is frequently attributed to traditional adjudication forums, can also be imputed to the formal legal system where patriarchal prejudice and majoritarianism influences decision-making. Another neglected aspect that governs the choice of fora is the socio-political climate in which the woman and community to which she belongs is located. As I've said before, there is a sharp ascendance in anti-minority speech and action which the government is implicitly or explicitly sanctioning. The fact that there is gender disparity in Muslim personal law is not necessarily a reflection of discrimination being inherent to Islam, but rather is a function of the majority-minority dynamics in India. In South Asia, Muslim personal law has undergone major reforms, both in Pakistan and Bangladesh, where Muslim community is in majority. In Bangladesh, it is the Hindu woman who has no right of inheritance, as the minority Hindu community has resisted and opposed any efforts to reform by the state to their personal laws. And I come to my last segment. So where does one go ahead for issues of gender justice and human rights? The feminist position, the women's movement position on UCC has undergone a marked shift from the pre-constitutional time when UCC was seen as the way forward to today when uniformity has been abandoned and not seen as a virtue at all, but rather what is advocated is equality through multiple strategies. And those multiple strategies, some of which I've already referred to earlier, are through strategic litigation in courts, are through campaigning for laws, like the Protection of Women from Domestic Violence Act. And it is through this that other routes, which would be less confrontational, less collision, and less attrition between religious minorities and the majority community, which may have the overt or covert backing of state institutions, is what the feminist movement is today advocating. Can somebody give me an indication of time? I have completely lost track of time. Okay, thank you. I was getting a little worried in my head. The women's movement, and there's no one women's movement in India, I would rather say the women's movements in India, which are strong campaigners, they have a powerful voice, have systematically foregrounded the question of gender-just personal laws while taking into account the diversity and plurality that exists in communities. Deeply critical of the UCC as a step towards achieving justice, they are suspicious of the straight project of Uniform Civil Code. The current debates within the women's movement and their positions on personal laws revolve around adopting multiple and simultaneous strategies strengthened through politics of alliance with democratic voices in all these communities. A comment by an earlier panelist regarding distributive justice and alliances. The women's movement seeks to make those alliances through different acts of solidarities with women from tribal communities when under attack from state forces on issues of economic and social rights. The women's movement similarly seeks to make alliances with women from religious minority communities when they are under attack in communal conflict and in communal violence, and their very right to life is threatened. Presently, the following processes are underway. Reform within personal laws initiated by women belonging to the particular community. B, strategic litigation challenging the gender discrimination in personal laws in areas of adoption, guardianship, property rights. Feminist campaign for law reform, like prohibition of domestic violence, to secure relief for all women in the personal sphere. And lastly, conceptualize and center stage issues such as right to matrimonial property, economic rights of women in marriage, re-envisioning the structure and hierarchy of family, as well as intercommunity and same-sex relationships. Same-sex relationship continues to be criminalized in India, and the matter is currently pending in the Indian Supreme Court. However, as was mentioned by an earlier panelist, transgender community has recently received recognition both through a Supreme Court judgment and now increasingly in policy. How would personal laws of a community be envisioned for a family of transgender persons? How would it be envisioned for a family of single woman-headed household? How would it be envisioned for a family of same-sex relations? To say that the law cannot accommodate or the constitutional guarantees have no space for such envisioning, I think would be denying the feminist imagination that is already envisioning and challenging and placing, both in the public domain and before the courts as well as the state, other forms on which the principle that exists is one of equity and gender justice. So the debate has certainly shifted from uniformity to multiple forms of equalities. Even as the political sphere becomes more contentious and divided, the gender inequity in personal law has been contested and chipped away through multiple strategies using multiple fora. It needs repetition that equality and gender justice, promoting dignity rather than uniformity or legislative clarity, are the end goals. The emphasis today is to reconceptualize the debate from uniformity and national unification, which was envisioned at the start of the emergence of the nation state, and shift the emphasis as well as the strategy from uniformity to equalities. Particularly at a juncture when the state in India is led by a political regime which is openly espousing a Hindu nation theory, it becomes important that the strategies that are involved and the feminist strategies that are involved are not one of condemnation, are not one of outsider critique, but rather one in which there are alliances and which actually strengthen the voices of Muslim women themselves who are raising the issue of gender inequality and seeking parity. And there are multiple voices within the Muslim community, within the Christian community, within the tribal community that are seeking this equality. And it is those voices and those alliances that the feminist movement in India seeks to strengthen. Thank you very much.
Thank you so much. And now to give our closing remarks, Dean Trevor Morrison.
Thank you, and good afternoon. Let me be the last to say welcome today, but also to thank our keynote speaker, Vrinda Grover, for those remarks. This is one of those days when I personally would wish that I could put my dean duties on hold so that I could have been with you all day, because today's topic of this year's symposium really is, I think, a terribly important one. And the issues presented by questions around women's rights and access to justice in constitutional systems that mean to be pluralistic and therefore need to confront questions about how to accommodate multiple belief systems, multiple value systems within a larger constitutional framework are deep and challenging ones. I think these questions are becoming more urgent, not less, more complicated, not less. And so I'm confident that good progress on these important issues was made today. My job mostly is in the nature of extending thank yous. I want to thank all of our panelists for joining us today. I want to thank the student organizations responsible for helping put on this event. I'm in particular grateful to our Professor Jose Alvarez, who's the faculty advisor to the Journal of International Law and Politics, who regularly goes above and beyond the call for what he does here for all of us at the law school. And so too does Professor Meg Satterthwaite, who's really been instrumental in putting this event together. Thank you, Meg. Thank you to Hannah Miller, the senior symposium editor of the Journal, and to Amy Zajac, the Journal's editor-in-chief. Thanks for putting together this really outstanding program. I want also, of course, to give a very special thanks to Rose and Herb Rubin. Without your continuing devotion, to the school and to issues of international law in particular, we would not be able to put on events like this. We really would not be able to continue to be the leading institution in this space that I'm very proud to say that we are. So deeply grateful to you, Herb, to your entire family, to members of your family who are with you today, your two daughters and son, and their partners. I want to thank also other organizations that have helped make this event possible, including from within the law school, the Robert Bernstein Institute for Human Rights, as well as law firm partners Sherman and Sterling, Freshfields, and Weil. There's a wonderful history to this series over the years in bringing together students and faculty with expertise in international and domestic law issues alike, together with visiting fellows, researchers, practitioners, scholars from other institutions. So I say this topic is both one of, I think, great and increasing importance, and in many ways is reflected in the global reach of this school. We are committed to teaching law, to studying and writing about it, and to preparing legal practitioners who are prepared to work not just within the jurisdiction of a single country, but across jurisdictions, and to understand the complexities presented by problems and challenges of pluralistic societies, of increasing complexity, and the legal questions that arise as a result of that. So I just could not be more thrilled that we've put on this event today, could not be more grateful to the Rubin family for their ongoing commitment to the school and to our work in this area. So I end then with a thank you to all of you for being part of this, to the sponsors for helping put this on, to the students for helping to organize it, and I look forward to seeing all of you next year. Thanks.